was a great start to our conference. The second panel, thinking right off from where we left off, is the subtitle of Teaching Law and International Affairs Students Learning from Each Other. This is a panel, as you can see and note from the bios, that is deliberately chosen to represent the international affairs schools and the legal academy. Experts from both sides, some of whom known each other, some I think a couple who just met. And moderated by my friend and colleague Steve Vladeck from the American University College of Law. I won't read Steve's bio, it would take too long. Steve is a very young man who's done many fabulous things in a short amount of time. He's incredible in a lot of areas, and he most recent, I think, is probably his biggest claim to fame is he just became a co-author of the Dicus Raven Hansen Banks textbook. He's done a few other things as well.
I've heard good things about that book.
Yeah. Over to you.
Great, thank you, Bill. Thanks, everybody. It's a real treat for me to be here. Let me just say that I'm never listening to Bill again about the dress code for a conference. Since as I recall, the instructions said business casual, but there I go. I guess my youthful exuberance means I can be informal. As with the last panel, our goal is to sort of get right into the substance. So I'm just going to very briefly introduce our panelists and say a bit about what our goal is. Bill already mentioned that, it's a segue from the last panel, which was about translating legal advice into policy. Well, now the question is, how do we translate national security law and policy into teaching? And what are the exact sort of pedagogical challenges we face, both as law professors, as IA professors, as security studies professors, in trying to turn this mishmash of law policy and current events into not just interesting classroom material, but actually useful and developmental classroom material. So with that in mind, the three folks we have up here certainly are second to none in that department. Our first presenter is going to be my dear old friend, and by old I just mean long-standing, Laura Donahue. Laura's an associate professor at Georgetown University Law Center, and she's the acting director of Georgetown. Fantastic center on national security and the law. And Laura's going to say a bit about her national security law simulation. After Laura, we have Mike Glennon, who's a professor of international law at the Fletcher School of Law and Diplomacy at Tufts University. And Mike, I think, is going to add to that conversation with some discussion of his book, of his approach to the classroom, and of sort of some of the choices we make when we teach this material. And last, but certainly not least, is Cindy Williams, who's principal research scientist in the Security Studies program, which is affiliated with the Political Science Department at MIT. And Cindy's going to talk a bit about the differences in security studies fields, how they confront the challenges when it comes to those kinds of grad students, and also talk specifically about her really very, very cool national security budget project. So that's our plan, and then I'm going to ask them some questions, and then hopefully we'll have time for you. So to lead off, we have Laura.
All right, thanks very much, Steve. So that was a terrific panel, the first one, and in many ways it laid out many of the problems that we face for our students, that our students face when they leave law school to enter national security law as a field. The problem is that traditional legal education, in many ways, I think, ill-prepares students for what they're going to need to do once they graduate. Now, there is one solution that I'd like to talk about today that came up, actually, first when I was at Harvard with Rich, doing the program there at the Kennedy School with the top-off exercises. So it started with top-off. Then at Stanford, we turned it into a tabletop exercise in law school. It's now been taught at Georgetown. This is the 5th iteration. And the solution I'd like to propose is a simulation. First, I'd like to, though, talk about the problem of legal pedagogy and why it's really ill-suited for the type of law that the panel before us was just discussing students are going to need to do. Traditionally in law school, we focus on the law as written. Students learn what the law is. The problem is that once they graduate, they're going to have to know the law is written and applied. Not just the legal authorities, but the relevant legal processes as well. They're going to have to understand the Washington context, the interpersonal communications, their institutional affiliations, and then the political overlay that you have in Washington, D.C. They're going to have to understand the policy environment. This L2P is the lawyer to policymaker problem that we heard highlighted so nicely in the panel before, that lawyers are used to talking to lawyers in law school, and suddenly they have to learn how to talk to policymakers. And in this context, represent law qua law and interject law into what is a policy discussion. It is one of many competing concerns, as we heard, that may be at the table. And they have to learn how to do that, not kind of already preaching to the converted, the other lawyers, but talking to policymakers. There are competing aims that are at place. There's a +1 problem, which is when they're not at the table. They're the +1 in the room. How do they deal with those types of situations where they have to advise somebody who may or may not take their advice? And then how do they deal with the implications of the legal advice that they give? They also have to be able to adapt and evolve to constantly changing circumstances. Second problem with traditional law school teaching is we give students the legal facts. We say, here are the facts of the case. All right, now we'll talk about the case. But national security lawyers often don't know all the facts. The facts may change. They might not even know what they don't know about these facts themselves. And so their legal advice has to be hinged on the possibility of those facts changing, making it transparent to their client that this is their legal advice based on these facts, but if they were to change in X manner, here's how it might change. And that's not what we traditionally teach them how to do. They have to learn how to deal with chaos, factual chaos. Information comes from lots of different sources in a digital age. They have to deal with uncertainty, and they have to be able to approach it from a very creative problem-solving perspective. The third thing in law school, we do a pretty good job of teaching critical analysis, but in the national security law world, it looks a little bit different. You have to teach them not just that critical distance, but, and this came up Mary's comments during the panel before, what legal options do you not want to put on the table? Why don't you want to put them on the table? What are the possibilities that are out there for how the policymaker can act? Fourth, we focus on written and oral skills that are very traditional. Legal brief writing, oral advocacy before the court, for which they have lots of time to prepare. They also have reasonably complete information. By the time they go to the Supreme Court, pretty much everybody knows the facts. But then the students, when they get out, suddenly it's going to be 90-second oral briefing before a policymaker. It's going to be a comment in an elevator. It's going to be an email. It's going to be setting the agenda of a meeting. It's going to be learning how to inject yourself into a meeting. These end up having a lot of weight in that world. How do we train them to be able to do that when they don't have all the time in the world? Jamie Baker has this great story where he had, 20 minutes to give legal advice on a major national security issue he had never looked at before. You know, our students are more comfortable when they know all the facts, they have time to prepare. How do we prepare them for an environment where they don't have that time and they still have to give their legal advice in a nuanced manner? Fifth, we teach professional responsibility in law school, but it looks a little bit different in national security law. And we heard it talking in the first panel about clients, for instance. Who is your client when you're a national security lawyer? If you're GC, who is your client? Is it the president? Is it the head of your agency? Is it the Constitution? Is it the American people? And how do you deal with this in a national security environment? There's increased pressure on individuals, especially when things are classified and may never see light of day. We have a number of judicial doctrines that prevent cases from going to court. We have classification structures. What happens when you don't have another lawyer with whom to consult? You might be the only one read into a program. How do you create frameworks for yourself to check your integrity and your legal analysis within that context? Finally, we tend to have in law schools where they learn, and then we send them forth into the world, to launch on their careers. But what about continuing that learning? How do you do that in a classified world where people frequently move jobs? How do you create mentors when mentors may not know what people are doing within that legal world? How do we teach them to create opportunities for their own further learning to continue to become better lawyers? And finally, how do we integrate this all at the same time so they learn how to do all these things at once? So those are the pedagogical goals, and the simulation and the course design is really meant to try to get at these other skills that aren't traditionally taught in a law school. And the way I do it is I start out first with a doctrinal course. It's a 5-unit doctrinal course where we begin with constitutional considerations, looking at war powers, U.S. national security, foreign affairs, war powers resolution. We move to Fourth Amendment, looking at national security information, investigatory authorities, FISA Title III. We turn to First Amendment, so classification issues, leaks, how that all works, federalism, state police powers, and what limits there are and how we define national security in terms of the constitutional basis. Then the second doctrinal portion of the course goes to domestic incident management. And here what we're looking at are domestic emergencies, where issues of federalism and state sovereignty, the National Incident Management Doctrine, all the policy kind of documents come in, and the role of the military. Then we look at cross-border security issues, whether it be drugs, nuclear devices, or people moving across borders, trade, and then cybersecurity, looking particularly at the threats and incident response, Titles 10, 50, and 18, and then cybersecurity, sovereignty, and Westphalia. Now the idea is that then we move into a process side, and this is the law as applied, where we actually have people come in who are lawyers in the executive or Congress or in private practice, where they look at the process of being a national security lawyer. So looking at NSC and the role of the interagency process, looking at the congressional role, what is the informal ways in which Congress works with the executive and with other agencies. Looking particularly at external norms and leadership issues. So we actually have people from professional ethics and professional responsibility come in and talk about the adaptation of professional responsibility in the national security space. We move from that to a simulation. And the first part of the course is 26 class meetings, 2 hours each, and the simulation takes place then over 4 days. And it is a total immersion simulation where we've created a national security crisis environment, a number of crises emerge, and the students who are put into roles in this environment have to respond as though they were in their positions at the time. So the roles are basically divided into 4 major groups. You have the National Security Council, where we represent the White House, State Department, DOD, the DHS, HHS, DOJ, and the intelligence community. For each of these teams that we put them onto, we assign them a professional mentor in the real world who has actually held these positions or been in those agencies to give the students an opportunity when they write papers leading up to the simulation to talk to people who've had to do those jobs, to understand how it's actually applied in practice. So they've studied the legal authorities. Now what they have to do is find out how does it actually work when you're in that position. From the Senate and the House, we have special committees on national security. They meet with congressional members to talk to them and staffers about the congressional elements. We have state and local government represented as well. This becomes very important for the federalism issues, the legal doctrines that emerge. And then we also have a media component, a very strong media component. We run both an AP Wire as well as the Video News Network, VNN. It's a broadcast network that we pre-record and then we record during the simulation, pulling players in front of the camera so that they learn that this is a 24/7, 60/60 issue and that the media plays a key issue, a key role in the evolution of national security. At the beginning of play, all students can sign on to this as a cyber portal. We developed a cyber world that they can sign on to. Basically, as you see from the screen above, we have team communication. So each entity can communicate secretly within its own realm. Students can innovate. They can create new tabs if they want to form a lawyers working group, some sort of way to communicate with each other. This is so that the control team, and I'll talk a little bit about the control team in just a moment, can see what's happening within the groups themselves. We have a digital archive, so it's a closed legal universe so that the students don't have too many legal authorities. With that said, it's about 5,000 pages of documents in the digital archives. They have read all of them prior to the simulation itself, either individually as a team member or as part of the course itself. So these documents, we also provide sample application forms like for FISA or Title III warrants or national security letters, so they don't waste time during the simulation recreating these documents. They're there and they can fill them out, submit them to the control team, and we either deny them if they're not sufficient legally or grant them and then we reward them with information that they've sought. We also have the AP Wire, which is like a public news network. We run a press, we run broadcast, also comes through the cyber portal. So the cyber portal runs for 4 days. As soon as class ends on a Wednesday, at any time, something could happen. This is, again, Jamie Baker's wonderful insight that you don't choose national security crises, they choose you. So we start often around 9 o'clock at night on a Wednesday. That's when things start happening. And part of the students' role is to figure out how well they perform when they don't have a lot of sleep. They have competing things that they have to be doing. And they have to figure out how they respond to a crisis at that time. This becomes a big part of their debrief afterwards and looking at how they perform in those kinds of situations. We have then a control team, and the control team is about 20 people. This was our last one, it's just a good example of it, where the control team takes on roles. And the reason we do this is to give the students agency in their decision-making process, and then to give them responsibility for the decisions they take. So when a student gets factual information and responds in a certain manner, we immediately respond from the control team. And so we have about 6 professors. Our dean of the law school plays president of the United States. He convenes the National Security Council in person in the Situation Room. Students are terrified, right, about performing in front of him, which is exactly what we want for a hierarchical system where they have 90 seconds to tell Dean Trainer what they think should be done about the latest cyber attack. And so this is how we build in those pedagogical aims into the sim. We also have judges. So this past spring, Jamie Baker, Judge Sean Bates came from Fisk, John Norton Moore was there as well. And then we invite lawyers who are practicing in national security law to come observe and then give the students feedback afterwards on how well they did. You know, did they do a good job or not? We also have a huge support team behind this. This is the physical space. On the 4th day, we actually meet at Georgetown Law, although most student groups have already reserved rooms throughout the 4 days, and they've been meeting constantly at the library and elsewhere. But this is how we set it up. We have the VNN broadcast station set up. They pull players in, they interview them. We have professional reporters who take part. We have then the control room. Any student entering the control room is immediately suspended from the exercise. That's just for the professors. The other thing I should add is we have many students who've been in the Sims before who are now working, who come back pro bono to be on the control team. So there's really a community that's built up around this Sim exercise that people come back for it. We have a situation room, and then we've divided each team. They have their own office space. Congress has a hearing room. New York has its own area, and then we have print media in that space as well. And I guess the best thing to do to give you an idea is I'm just going to show a short clip. This past spring, the school recorded the sim that we did, and it'll give you an idea of kind of how we do it. Let's see, and why we do it that way.
As you may be aware, there have been cases of smallpox in the New York area. Local, state, and federal officials are working in conjunction to effectively respond to these cases. Second, there is a nuclear reactor experiencing complications in Uni, New Mexico.
The simulation really grew out of this top-off concept, the top officials exercise, which is run federally as an effort to test for chemical, biological, nuclear, radiological terrorist attacks. Unlike the top-off exercises where the law was really sidelined in many ways, in this exercise it's centerpiece along with the policymakers' decisions. The way that the simulation works is you have the control team that's basically running the simulation behind the scenes, and we also have professors that actually convene those meetings to push the students to decision-making points. The students actually are divided into 4 main groups. They play the National Security Council, and within the National Security Council, there's the Department of Defense, there's the White House, there's the intelligence agencies, so ODNI and CIA. There's the Department of Homeland Security, the Health and Human Services, Department of Justice with the Attorney General and the FBI. In addition to the National Security Council, there's a congressional element to it. So students also play in congressional committees with budgetary authorities, and they also can subpoena individuals who are in the simulation to appear before them. So you have the NSC and you have Congress. The third major grouping is the state government. So we have the mayor, for instance, of New York, as well as the governor of New York, with the adjutant general. So we have National Guard elements in it, as well as public health officials and police.
I'm just going to issue an executive order declaring a state of emergency.
And the fourth is the media element.
New York City Police are isolating smallpox.
The Video News Network runs when you're in a world that's rich in information, how do students figure out what's the relevant information? And so we have newscasters on BNN who have done stories beforehand and who continue to interview the players and release news stories during the simulation.
The Pakistani and Russian officials are aware that vulnerabilities in their servers have been exploited.
They have to take what matters, and they also have to figure out which information they're getting from BNN that is irrelevant.
It's certainly chaotic for the participants, but that's what it's supposed to be. So it's a lot of fun.
We were very fortunate this past year to have 3 of the most prominent experts in the country actually take part in the simulation as judges. So the Chief Judge of the U.S. Court of Appeals for the Armed Forces, James Baker, the Chief Judge of the Foreign Intelligence Surveillance Court, John Bates, and Professor John Norton Moore, who really founded the field of national security law.
Your recommendation?
Dean Traynor served as President of the United States. When they're in front of the dean, they have to perform. So if they have 60 seconds in front of the president, how do they treat those 60 seconds?
It's almost impossible for us to follow the usual restrictions of 10 U.S. Code 637.
We're going to have to try to remain compliant with international law, particularly the UN Convention on the Law of the Sea.
We invited observers who came and gave us feedback on the simulation itself, and then they also gave the students feedback on their performance.
I think the biggest compliment that I could give to you is I felt I was back in an interagency setting, in an NSC meeting.
This is phenomenal. There's no other law school, there's no National Security Center that's this advanced really in doing what you're doing.
I think that this is absolutely critical for students to be able to perform in this world, because in a simulation you not only have to know what the law is and have critical distance from it, which are skills we traditionally teach in law school, but you have to know the difference between legal authority and political authority. We need to be able to create a training ground for them to do this when the stakes aren't as high as they will be when they leave Georgetown and international security law as a field.
So that gives you an idea of just how the simulation itself unfolds. I'd just like to conclude with a couple of remarks about, first of all, the design of the course, how it's actually developed, and then just a final kind of observation about how this worked for our students. So the way that we do this is the first thing we do is the course really starts with a doctrinal foundation. So we start by looking at the constitutional, statutory, regulatory, and case law applied to a particular area, such as quarantine. So if we're dealing with smallpox, for instance, we start with that. We move from that then to developing a narrative that plays to the interstices in the law between public health, for instance, and national security, or between drug interdiction, organized crime, terrorism, and war. And we develop these narratives. Then we map them out, hour by hour, 4 or 5 storylines at once. So at any one point in time, the entire control team knows what's happening across the board in each of these particular storylines. We then divide it up into different kinds of injects to get to this information chaos and information overload. Some of the information will come to them through security, classified communications, some will come through the AP wire, some will come through the news network, some of it's going to be completely irrelevant to what they're doing, and they have to figure out that information. So we might, for instance, here we had the Honest John Society. We created a right-wing militia group in upstate New York, and we had a BNN broadcast talking about the Honest John Society. Then later on, we have an AP Wire that comes out developing the Honest John Manifesto. Here's an example on the AP Newswire where the manifesto comes out itself. Just to conclude, the nice thing about this, it's not the only solution. Obviously, there are many solutions to the problems that were identified by the first panel. It's one solution, one possible way to address this problem. And the nice thing that comes out of it is many of those pedagogical aims can be met. So the students learn the difference between law and process. They learn the difference between the law as written and the law as applied itself. They're forced to engage in careful legal and political analysis. And so we have general counsels, but we also have policy positions. And Bruce Hoffman over at School of Foreign Service, so he sends students over. Now the students are taking the law course itself, and we can talk a little bit about issues when you have non-law students taking doctrinal courses. The way we've addressed it at Georgetown is the School of Foreign Service actually has a lawyer from DOD, actually, who's who's teaching the SFS students how to read cases and kind of the basics of lawyering so that they then can do well in the course, although they'll ultimately play policy positions in the exercise itself. And this is to help them get up to speed on the legal side of the issues as well. New York watching it. The level of adaptation and creativity that the students demonstrate is really extraordinary. This is, for example, she was National Security Council staff. She came up, this is one of the students on the course, she came up with about a dozen different diagrams for how to think through problems when they arose. The White House could take a leadership role vis-a-vis the other students. This was our dean finding out we just attacked the Russian servers. And I think my favorite is John's response to this. He's cracking up. You know, the nice thing about our students, I have to say, is the gentleman who did that is a Navy SEAL. I'll show him a little bit later. He was in a Cyber Command, and he got tired of the bureaucratic kind of dragging a feet that the other students were showing, and so he was, as Judge Baker put it, forward-leaning in the exercise. And it made a huge difference for the learning that went on. So, you know, one time I had a DHS secretary who got a tularemia hit on the BioWatch system. That was our, you know, in our factual pattern, although we didn't confirm, it turned out it was a false hit, which happens, right? So, but she evacuated the Capitol without checking with the White House, right? So the White House went ballistic, and she's like, but in the law, like, that's my authority. You know, and then, yes, but, you know, that's not just what it's about, right? There's this bigger political context and institutional context. And it's better they make that mistake at law school and not when they leave. This is a good example of the +1 participation. So here we have the General Counsel talking to the Secretary of HHS, who repeatedly did not take his advice, which he found very difficult. And it became the subject of the debrief afterwards. He wrote papers about this. He came to talk at office hours about it. Because, you know, what are your options in that circumstance, especially where you feel that your principal is acting contrary to the law? What are your options? Who is your client? So the issues of professional responsibility that came up were very serious in this regard. This is Elle talking to the Secretary of State in this, and the lawyer to policymaker. She's from the School of Foreign Service. She had no legal background whatsoever, and so he had to constantly explain the legal issues to her. There was a lot of initiative that had to be taken during the exercise itself. Congress, in the course of it, you know, drafted and passed committee rules. They amended the Stafford Act. They ratified the law of the seizure. They were very active. It was quite impressive, actually. It's actually very funny. They're terrific. But they were also frustrated because they weren't in the room. They weren't making the decisions, you know, and it was important for them to see what their role was in the midst of a crisis and the timeline, the horizon that they operate under versus the horizon that the executive operates under. This is our DCI who had some problems with some leaks that happened because we have SCI, secure compartmentalized information, that's only given to certain players, and when this became public, he had to take action in the midst of all these other things that were going on. As just example of leadership and good judgment. Here we have our General Counsel of DOD. I guess the final thing is we just have an extraordinary faculty and support from lawyers in the field and students. So we're able to integrate JD students, LLM students, fellows, lawyers in the field, professors, and really bring it in both horizontal across to the School of Foreign Service as well as the law school, but vertically to bring to the students the opportunity to really develop skills that they otherwise wouldn't have a chance. Some of them are more enterprising than others. The Democrats ran a re-election campaign for Bill. As part of this, they held a cocktail party, but then there was a Hatch Act violation, which the students picked up and ran with. It was very funny. So the information really makes it worthwhile. Thanks very much.
Sorry. Well, thank you, Bill, very much for putting on this marvelous symposium. I'm going to say just a few quick words about a different kind of simulation approach, which I guess is, in comparison, somewhat primitive and bread and butter. It nuts and bolts, doesn't even have a soundtrack. This is something that was developed a long time ago. In fact, in the 1970s, I think, in 1976, Tom Frank and I sketched out on the back of the napkin in a restaurant in the Greenwich Village the outline of a casebook that we would put together to back up this little seminar that we were beginning to teach. And over the years, this has been refined, and I think we're now out with the 5th edition of our casebook. I talked to a lot of people in putting this course together. Initially, Tony Amsterdam of the NYU clinical program, really the famous founding clinician at NYU, and Lou Henkin was very helpful. Sean Murphy and Ed Swain are now the co-authors of the casebook in Tom's unfortunate absence. But we started out calling it foreign relations law, and I think over the course of the years it evolved into foreign relations and national security law. I'm not sure that we ever really distinguished between the two, and it kind of evolved into a work that conjoins the two. I'm going to say a few words today about the substance of this set of simulations, and then talk about the pros and cons of the particular approach that I'm going to describe that Tom and I developed, and then conclude with a set of ways that I think are useful to try to make it work, methods that are directed at making it more effective. Our seminar hasn't changed in one fundamental respect since 1977 when we first taught it, and that is it's divided into two parts. The first part in the seminar, I might add, meets once a week for one semester. The first part consists of 4 weeks in which we try to identify recurring issues that will come up over and over during the course of the simulations. The remaining 9 weeks then involve the students in role-playing in the simulations that are set out in the casebook. So let me talk first about the first part. We have as our objective forcing the students to think through an analytic framework and to develop an analytic framework that will work consistently through the course. And by consistently, I mean, in Tom's phrase, a neutral principle approach. An approach that recognizes that, you know, you're going to have presidents in the White House other than Barack Obama. Sometimes you'll have George Bush. You won't always have a Bill Fulbright as chairman of the Senate Foreign Relations Committee. Sometimes it'll be a Jesse Helms. So you've got to come up with a set of principles that work across the boards, regardless of the identity of the political actors involved. It's kind of Rawlsian original position, veil of ignorance approach. And so we tell the students, you know, here are the questions at the outset of the course that we want you to think through very carefully and just kind of refine your analytic framework as we go through the simulations. You need to think about the sources of constitutional authority, about the constitutional rule of recognition. How do you identify the meta rules? What are the meta rules by which you identify the primary rules in a Hardian sense, the primary rules that govern the resolution of constitutional conflicts? So you need to look at the constitutional text and think through when it's permissible to go beyond a text, the text in a kind of plain meaning sense. You need to think through the weight that should be accorded the intent of the framers, how you identify the intent of the framers, and all the problems with originalism that have come to light over recent years in the philosophy of Justice Scalia. You need to think through the whole issue of constitutional custom, when it is formed, the role of acquiescence, how you identify consent, the weight to be given custom when it runs up against the intent of the framers or the text of the Constitution. You need to think through the whole process of constitutional common law making and the effect to be given to prior cases, which in many cases concern the earliest days of the Republic and which are arguably, inapposite given that they were decided by a martial court and presided over a seaboard agrarian economy of 3.5 million people. That doesn't confront the issues that a modern superpower confronts. And finally, think through the effect of functional considerations, of the institutional advantages of assigning a power to one branch or the other. So the idea, again, is to set up a kind of provisional analytic framework and then work it through as we go through the course. We then move into simulations, and these simulations are little, and I do mean little, 1, 2, 3 paragraph sets of issues that have been developed over the years and refined over the years, in which students play roles. They involve, for example, constitutionality of the War Powers Resolution, or treaty termination, or any one of the many issues that have been talked about here. And the idea is to have students play, say, the role of a legal advisor opposing the role of counsel to the committee, frequently in congressional hearings, often in proceedings of appellate courts, and then after each of the students makes a 10-minute presentation, the class is opened up to cross-examination. So everybody participates in every class. Everybody participates. And at the end of the class period, we have about 10 minutes, and the instructor then wraps things up and opens it up to questions directed at himself or herself to try to tie together some loose ends. So the advantages, the obvious disadvantage of this approach is that, number one, you need a small class. It only works with about 10 to 20 students because they all have to have an opportunity to do at least one major presentation and to cross-examine in every class. You got to give every student about at least 5-10 minutes to engage in cross-examination. Second, students have got to be pretty smart, because when you rely upon students to this extent to carry the class discussion, if a student is not well prepared, I must say that that's not been a problem. We've had extremely devoted and dedicated students in these classes, and because they are on the spot, they tend to prepare pretty extensively. The difficult thing is the mix of students that occurs at a place like Fletcher, where I teach. We have, out of a class of 15 students, you have a handful of students from Harvard Law School and BC Law School, and Fletcher students who, may be foreign service officers who are on leave for a couple of years. And then you'll have a few other students who just don't have that sort of background. So there's a great disparity in the approach. The result is that the instructor frequently in these circumstances has to step in and try to even the odds. How do you make this work? Well, the first thing that you got to do is ensure that the fact situations that you give the students are evenly balanced. It doesn't work if one side or the other has a much stronger case. Second, and I suppose this is a paradox that every academic confronts, there's the perennial issue of how much of your own views should you reveal during this process. On the one hand, you don't want to be a proselytizer and a propagandist for your own viewpoint on any of these issues. But on the other, you don't want to play hide the ball, and for purposes of full disclosure, students believe, and I think correctly, that they have the right to know what the professor thinks. So I tell the students at the outset of the course that I'm going to play devil's advocate repeatedly, and I dive in on both sides of the question, and then at the end of the class I'm completely, I hope, open and honest about what I really think. It is sometimes the case that students are excessively polite. Students have gotten very polite over recent years, and it does tend to dull the vigor of the process of cross-examination. So I try to hold their feet to the fire and encourage them to abandon their instinct for the jugular and to be kind to their fellow classmates and try to, insist upon answers and to pursue witnesses to a corner in which they take ridiculous positions. Towards the end of the semester, they're less inclined to do that. They internalize the wisdom of this phrase of Justice Scalia from the healthcare case when he asked Solicitor General Borelli what the limiting principle was. By the end of his position, by the end of the course, students have recognized that they need to decide where the line is drawn and not give the whole loaf to the executive or the Congress, but to come out with, again, a reasonable position that works regardless of whether your friends or foes are in the White House or in a congressional committee. There is I suppose nonetheless I must confess one way, probably two ways, that I am nonetheless a proselytizer. Number one, I am a process proselytizer. I try to encourage students explicitly and overtly to appreciate both sides of the argument, to be able to make both sides of the argument, and to recognize that as a good lawyer, if you can't make both sides of the argument, you can't make either side of an argument effectively. And I suggest to them also that particularly the law students, have been indoctrinated with a view of law from these casebooks that they're studying that really is inaccurate, and the law doesn't really work that way. And I refer to the comment that Joel made on his panel. I think it's even worse than that. It's not that law involves so much more than appellate cases, but if you go into these kinds of controversies in foreign relations and national security realm, thinking that you can make predictions about how legal disputes will come out looking only at the cases in the casebook. This highly formalistic, wooden, 19th century way, of Langdellian way of analyzing cases, which is still prevalent in American law schools. You're just going to be completely out to lunch in advising clients in the realm of national security law. Early on in the course, I might add, I go through, line by line, I go through the War Powers Resolution and explain to them why it reads the way that it does, why the conference committee, I had the privilege of being the counsel to the Senate conferees that drew up the War Powers Resolution. So I go through and point out the competing political philosophies and histories and personal relationships and friendships and animosities that caused the War Powers Resolution to come out the way that it does, and to suggest to them that that's, writ small, the lawmaking process that we're dealing with. So I'll conclude just by underscoring one of the points that Laura made, and that is the tremendous role that uncertainty plays in a proper understanding of national security and foreign relations law. With these simulations, the students constantly are pushing the instructor for more facts. They don't like ambiguity. And I tell them repeatedly, look, this is, the way the real world is. Life is uncertain, and you never, as a decision maker, have enough facts to make as solid and reliable a decision as you would like to make. A part of the job of the lawyer, part of the objective of this course is to understand how public institutions should respond in the face of empirical uncertainty. So I think properly structured, this is an exciting thing for students. They tend to internalize the law and an analytic framework much more effectively, because it's fun, much more effectively and thoroughly than they do in the usual Socratic dialogue or lecture format of a classroom. And I think it as I say, has turned out to be a very enjoyable intellectual experience for both the instructor and the students in this format that combines analytic rigor with topicality. Thank you.
So I wish I could say I was as mean to my students as Mike was to his. You can see I'm sitting in the non-lawyer seat of the panel. So being the non-lawyer, I come from a group at MIT called the Security Studies Program, and I thought before I get into pedagogy, it might be helpful for a lot of you just to hear how we practice security studies. What is it we mean when we say that? Because it is an odd duck kind of field in a lot of ways. At MIT, it's a unique subfield. Security studies is a subfield of political science. At many schools, it's a subfield of a subfield. So it's a subfield of international relations. We right now anyway, have our own unique subfield, so our graduate students can test for their general exams in this as one of their two subfields, and when they finish, they really are meant to be security studies experts. The things that typically we're concerned with grand strategy as one of the very top things, and by that I mean sort of a country's theory of how it's going to protect itself in the world and how it's going to achieve or protect its vital interests in the world. But we're also very concerned with questions about conflict. How does conflict start? How does it proceed? What does a military operation actually look like? We're concerned, therefore, with military technology, and some of our students are are engineering specialists before they come into the security studies program. We're interested in U.S. defense policy, wider U.S. national security policy, but we're also interested in militaries, including the U.S. military as organizations and the military services as organizations. And we're also very interested in civil-military relations and in the domestic politics of security. And so with all of that said, it means that we are looking to a wide variety of fields for getting our information as we conduct our research, but also for pointing our students toward things to read or things to do or experiences that they need before they can really be proficient in this subfield. So we look, of course, to international relations. And the first and most fundamental thing that our students learn about is international relations theory. Some of them are approaching that in a traditional way. They're thinking about a realist paradigm or a liberal paradigm of how nations get along with one another in the world. And they're doing case studies to try to establish their own thinking in a theoretical sense about how countries conduct themselves, how they find themselves in wars, and so on. But there's a sort of a newer bent in international relations where people are looking at what's happened over many years with many countries as they make their decisions, say, about whether or not to go to war. These are the ones that we would call the large N studies, and probably the one that you might be most familiar with is the notion, it's what people call the democratic peace theory, and those who adhere to that theory would say, look, if you look at all the countries of the world over many generations, we find that in general, democracies don't go to war against each other. So, okay, that's good to look at it that way as well. Well, if those were the only two things that our students did, they could come out as IR specialists, international relations specialists. But we are very interested, at least at MIT, and I think in most security studies programs, in making sure that they're also drawing on organization theory, because they need to think about how militaries are, they need to think about how militaries relate to the civil sector. We need them to know something about diplomatic and military history, and we often draw on the work of historians to inform our work, but we also often send our students off to try to learn actually how to deal with an archive, how to get in there and noodle around and figure stuff out themselves in historical archives. They have to know something about geography, or they can't figure out how wars are prosecuted, because a lot of that has to do with the geography that you're facing. I came at it not as a political scientist. I came into this field from the mathematics field of operations research. And some of our students come at it with that bent as well, and we obviously inform ourselves from operations research work when we're trying to think about, well, would this military tool be more effective, for example, than that one? And then finally, I'll just say we distinguish ourselves from other parts of the international relations world by really caring about the nitty-gritty of how wars are conducted, the nitty-gritty of military technology, the nitty-gritty of how militaries work. And even though we're often looking at the past to try to develop our theories and do our case studies, we are always interested in the security problems of today and tomorrow. So with that as a background, sort of what we think we're about, you can get a good idea of what we think we should do pedagogically. And I've got three things that I'll talk about that we think are super important from the point of view of pedagogy with our students. The first is that they should be persistently thinking about what's going on today. Even if they're thinking about how World War II unfolded, even if they're going back to to the history of World War I, they should always be thinking about the security problems today. And that means that our course on East Asia this week is discussing the South China Sea, the issues that are going on there. Whatever else was on the agenda, whatever else was in the syllabus for this week, they're talking about what's going on with the islands of the South China Sea. It means that last year, when we had a course on military interventions and how they unfold and how they typically work, when it looked as though the U.S. might be poised to intervene militarily in Libya, everything else stopped in that course and they did a unit on what was going on in Libya. It also means that in general, everybody's syllabus includes current policy documents as well as books on political science or political science theory. Another thing that means is that, for example, in my course on military budgets, one of the things we routinely do is have just a brief discussion of current events at the beginning of each session. Just because, well, if you're talking military budgets, there's always something in the news about military budgets because something's always going on the Hill, or somebody's always in the middle of complaining that they don't have enough money. So there's always a current event, a juicy one to talk about in my class at every meeting. We also, in the assignments, challenge our students to come to grips with contemporary issues, not just with history. Okay, the second thing we think that our students should know is they ought to know something about how militaries work. They ought to know something about the military weapons, about operations. So we have a course about conventional forces, how conventional military forces work. One thing they do in that course every time is a little case study about how the Battle of the Bulge unfolded in World War II, because that's one that pulls together just about every aspect of military power on two sides, and for the students to understand how that works is important for them if they ever want to look at conventional forces themselves. We have one assignment in that same course is that every student has to conduct his or her own military campaign analysis and write that up as a paper. So they really have to name a potential military problem. A few years ago, 2 of our students worked together to do one about, well, how might an Israeli attack on the Iranian nuclear facilities unfold? What might that really look like? Do the Israelis have the legs in their fighter planes to even get to the nuclear facilities in Iran and get back, right? Or will they be so stretched that the U.S. would absolutely have to intervene if they started that? So that actually ended up in a major journal article for those students. But that's the kind of thing we're trying to stretch our students to do. Last spring, one of our students looked at, well, how might a war in Syria unfold? How might a U.S. intervention in Syria unfold? So, okay, another thing that we believe is that students should learn by doing. And so we also have policy simulations and crisis simulations. We do a lot of that kind of work with our students. For my own students, we have one little thing we play because I don't know how many of you ever read a national security strategy, but if you ever had to read one, I'm sure you went to sleep, right? So we play a game in my class because the students have to read the national security strategy and they have to figure out how that links to the budget. So we have a game called Name That Strategy, and we have a game called Name That Budget, right, as to how the budget links up to the strategy. Because if they don't play a game like that, they can't really make all those broad words real. And so this gives them a way to stay awake while they're reading these documents.
Is it a drinking game?
Well, now I'm going to tell you about the drinking game. This is actually one that our students developed for themselves. They developed one called Name That Weapon System, where one student pulls up a weapon system photograph on the web, and the other student has to say immediately what it is and how it works. Now, this is students, playing a drinking game, but it turns out it's actually very beneficial. Later, when somebody says, oh, the F-22 versus the F-35, they know what they're talking about. So I just want to end with something that I do in my class that I think it's fun for them, but it also pulls these various elements of pedagogy together. And that's for their final project on the budget. I want them to develop the U.S. national security budget. And all through the course, they are learning about the fact that actually ought to have some tie to the strategy. It ought to have some tie to the policy. The budget can be thought of as a kind of window into what the genuine policy is, no matter what the rhetorical policy happens to be. And so what I usually do is challenge them with a combination of fiscal guidance and policy guidance to come up with a soup to nuts kind of thing that would happen for defense inside the Pentagon, but also for the overall executive branch to consider what's going on in Homeland Security and the State Department as well. So I think this time, I know exactly what I'll do this time if Governor Romney wins the presidency. And that's that they are going to be his transition team. My students will be his transition team. And I will give them fiscal guidance that corresponds to the Budget Control Act of 2011. In other words, there will be a 10% cut to defense and everything else starting on January 2nd, and that will endure. And on top of that, I think I will make them include in their budget anything that the governor has promised. Since the governor last week promised to return the F-22 to production, which would cost maybe $2 billion on top of the $200 million every airplane is going to cost, just because that line's closed now, they'll have to fold that into their budget, and they'll have to try to think in the way that President Romney would want them to think about how he sees the world and how he sees U.S. foreign policy and the role of the military and the security establishment in the future world. So this should be fun for them. It should be really challenging because it's going to be a really tight budget, very hard to work under those fiscal constraints with the sort of very wide notion of what the United States has to do to secure itself, and a few little bits of domestic politics going on because of promises that have been made on the campaign trail. So that's the kind of thing I like to do. They'll have to come up then with the grand strategy, with the military strategy that supports that, with the force structure for the Army, Navy, Air Force, Marine Corps, and also for the sort of the shape of the domestic departments, how that will look, and what equipment is going to be purchased, what equipment is going to be foregone, and finally the bottom line of the U.S. national security budget. So I think I'll stop there.
So I want to leave time for some questions from the audience, but I have two questions I'd like to put to the panel first. So it seems like in the sort of the inherent difficulty in trying to translate national security law and policy into the classroom may be exacerbated by a related structural problem, which is disagreement about what national security law and policy actually is, right? And so I guess my first question for the panelists, and maybe Mike, I'll start with you, is, I was taken by the comment, right? I mean, your book is still called, right, Foreign Relations and National Security Law. Obviously, there are I thought you were usefully agnostic, right, about whether that's a conjunction or a disjunction. But I wonder if part of the problem that we have, whether it's in security studies, in public affairs, international affairs programs, and law schools, is that national security law, whatever it is, has changed so much from what it was 10, 15 years ago. So much so that, when my students ask me what it is, I say, well, what isn't it? Because, I'm a rhetorical smart-ass professor. So I guess I'm curious, is part of the problem here trying to figure out what this actually encompasses as a limiting principle on what we're conveying to our students?
I have to confess, maybe it's an admission against interest, we just haven't given that much thought to what label to put on what we're doing. And our operational premise is that the pivot points in the cases, in the key cases such as Curtis Wright and Steele Seizure and Little against Bareem, have remained pertinent, and the facts of the disputes may have changed, but the fundamental arguments are essentially the same, and they trace back to the early cases and the Federalist Papers. And whether you put on a template, a factual template concerning cyber conflict, or whether you're talking about the seizure of the vessel at issue in Little against Bareem, the issues of great questions of presidential power and the role of the elected representatives of the people and the extent to which the courts should intervene are fundamentally the same. So we tend to, in short, address these issues at, I suppose, a more basic level than the other two panelists.
So it's funny, I recently changed my views on this in a 160-page law review that just came out.
That some of us have read.
That Steve has commented on in depth. The way we deal with it in the class is basically we raise this as a very important question, and the reason it matters has to do with which constitutional authorities come into play. It has to do with which area of the code we just went over in class actually on Wednesday, Title 10, Title 18, Title 50, Title 32, to talk about different areas of the code, so which statutory regimes apply. It matters for which instruments you use in the course of investigations, if you're filing Title III or FISA or SLs, where you are. And so it actually is one of the themes that permeates the course. Fortunately, we're time limited, and so you have to choose 3 or 4 areas of the law that you get into as a doctrinal matter. And then you use those areas as a way to shed light on how we think about national security and how that thought process would change depending on how you classify or consider a particular threat that you face as a lawyer.
So I was really interested in Laura's point about bringing some of the students over from the School of Foreign Service to get them some law training, get them at least to think about the law, because even to think about Steve's question, you would have to presume that my students give a damn about the law. And generally, they don't, right? They don't come because they're interested in the law. They come because they're interested in how countries get along with each other, and the last thing on their minds is that part of the way they get along with each other is treaties. And so the first step that I ever take, and I am not a lawyer, right, but I actually think this matters, the first step I take with my students is to get them to read a law, any law. Sit down and read a treaty. Sit down and, read what's happened lately. Perhaps you haven't heard anything about new recent international laws regarding the treatment of refugees, right? But that's going to matter to you one day, and you're going to wish you knew that. So read a law. This week my class was all about the Budget Control Act of 2011 and how sequestration will actually operate, and to get them to go read the Budget Control Act, see what it says. Miracle. Yesterday in my class, 2 students brought up laws. Whoa. One said, there is a separation of powers regarding the military that's written into the Constitution. I'm going, yes, the student talks law. And another student brought up Title 10 of the U.S. Code, which is the title that basically says how the military should work and what its roles are, at least on the active duty side. And so one of the students understood that Title 10 lays out what the service roles are in particular. But this is different from being in a law school setting where it's just taken for granted that the students there all care about the law. Our students don't know what it means to them. Now, the second thing that's a challenge, I think, for us regarding the law is how much international norms are changing and how much it seems that the cart gets put before the horse as the norms change, but before they're written into international laws. And so one example would be that one about the refugees. There was some movement in the norms well before there was movement in the international law. Now we're seeing another thing in the responsibility to protect, the sort of movement in the law following a movement in the norms. And so to get the students to try to decipher which is which, and to ask themselves, are these the evolving norms the ones that we hope the world will be operating under in the future? What might be some of the second-order consequences of those norms, and how are they in tension with laws, international laws that have been there, or international norms that have been there for a long time? This is it's one of the things that we try to challenge our students with.
So I guess my second question, building off of that. So Cindy, you mentioned in your opening comments the sort of tying in current events and the value of tying in, the headline grabbing stories to our students. And I suspect, we can all relate to the value, right, of debating what's hot in our courses. There's a flip side to that, though, right, which is sometimes the distance of history is actually a useful sort of neutralizing force in sort of allowing students to approach an issue. I mean, for example, in the Dykes National Security Law book, there's a chapter on how we got into Vietnam, which my students, let's just say, a lot of that was news to them.
Vietnam or the
all of it. And I guess, but so the question I have is actually meant as a serious one, right? Which is, even though there's a degree of sort of trying to stimulate the students as best we can, is there actually sort of a danger to sort of to teaching in a field where everything changes every day? Last year I was teaching the law of detention while Congress was debating the NDAA. Right, it's like, oh, well, today it says this. Oh, wait, today it says, nope, now substantial support is back in. I mean, would we be better off actually maybe teaching from a more distanced perspective?
I'll take that from the point of view of political science, which I am not a political scientist, but I don't see any reason for our students to want to become political scientists if they're not willing to argue politics. And so I think it's something we need to teach them in the class, that there's a way to do it in which nobody has to walk away offended, nobody has to walk away, angry, furious, and it's up to us to help them learn that.
So I'm an historian. Actually, that was my first calling. And so I start constitutional law with the signing of the Magna Carta at Runnymede, then the beheading of Charles I, the restoration of William and Mary to the throne, the English Bill of Rights. Eventually we get to George III. the Declaration of Independence as a criminal complaint against George III, then the Constitutional Convention, and then eventually we get to Marbury versus Madison. But we do
but then
also.
You stop, right?
It's my originalist privilege. My complaint with originalism. But we get to the ACA as well, and we debate that as well. So I think there's room for both, and there's room for both in constitutional law, there's room for both in national security law. So when we talk about the Fourth Amendment, I go back to the church hearings, and I talk about the evolution of the intelligence community from pre-World War I put up a blank slide. I say, well, here's the IC then. And then I put up the IC now using data mining software. And it turns out it's just this incredibly complicated web. And I say, now how did that happen? And so we go through the history of it. But that doesn't prevent us from dealing with things like cybersecurity and figuring out exactly who in the intelligence community should have ownership of that, which parts of that, and how that relates to the private sector, government actors, and individuals within the government or within the state.
Maybe I should have mentioned this earlier. I'm not actually teaching the seminar this semester or this year on foreign relations and national security laws because of precisely the reason that Stephen mentioned. I have been so angry with the lack of education in American history that our students have. I decided to teach a course, and it's the first time that it's been done at Fletcher and Tufts, on the United States Constitution to Fletcher students as well as undergrads, advanced political science undergrads. And it's a course that combines, as Laura's does, constitutional history, American history, with the case law. And it's amazing to me how many students have come up to me after class when I talk about Lexington and Concord, which are, for gosh sakes, 16 miles away. And tell me that they never heard of that because the history course that they took is entitled Girlhood in the 1950s, So I go through basic events in American history, and it's like teaching people from another planet that, they're in a country that has an extremely interesting history and governed by a constitution that was written by some extremely impressive people. And 90% of the slides for my course, I use PowerPoint for the first time, against all my instincts, are paintings of John Adams and Thomas Jefferson and George Washington. And I never knew any of this. And so I think that, Stephen has really put his finger on something, and this is the direction in which we need to be moving.
At the risk of contradicting myself, I want to second that. We have a problem in the way that history is taught in the United States in general, in my opinion, and in the opinion of those of us in the Security Studies program, that does go back to this thing about whatever you said, girls in the 5th grade. It's that there almost is no diplomatic or military history being conducted in the United States anymore. The few departments that have a diplomatic historian left tend to treat that person like dirt. The same goes for a military historian. I mean, basically, if you want to find a military historian, you should go to Oxford because we don't really have them anymore. Now, we do have a few, and the security studies field of political sciences started putting out sort of tentacles to reach into that community and try to make sure that they continue as an academic subfield of history, because it's very not the done thing right now in history departments. And to some extent, if it weren't for the war colleges teaching it, we wouldn't have much of it done at all in the United States. So I'm with you on that. We're all for it.
Let me just pile on though, and then I want to get to audience questions. The pile on comment is, so in both common law and national security law, I teach ex parte merriment. And I want to add to the sort of deficit of historical knowledge, geographical knowledge, because I try to get my students to understand why they're cutting off the railroad lines through Baltimore to the nation's capital might have actually been an existential national security threat in April of 1861, such that Winfield Scott might have actually thought it was necessary to suspend habeas in order to secure the nation's capital. And they just don't understand it. They're like, well, but why? I'm like, how else would you get troops to the nation's capital? Like, well, you can sail them up the... I'm like, no. Like, well, you can bring them through the... No. Right? I mean, so I would add geography to history. Anyway, with that, why don't we throw it open to questions from the floor? Yeah, John.
Just let me add my violent agreement with the panelists about the difficulty of teaching law when people don't have a good foundation in history. And it does extend... You can teach the Cali case, they have no clue about the My Lai massacre. In fact, I put up some of the classic photos, iconic photos, and most of the students have never seen them before. And in a way, that's the case study that, other law schools outside Georgetown can use. But let me ask Clark, how many credits does a student get for that? How much does it cost to put that on? And did you get any pushback from the faculty if you have your students, there'd be a nuclear explosion, I think, with the tasking of 5,000 pages for one course. Did you get any pushback from the faculty? And how do you grade them?
Oh. So the course itself, it's steadily gone up in credits year by year. We're now at 5.
22.
22, yeah, no, it's now at 5, and the students we tend to get are very serious national security students. So many of those that you saw, they're all going into the field. So one is now at JAG, one's now at L, one's going to DHS, GC's office, another one's going to the ACLU, one's going to the Constitution Project, their national security things. These students are very dedicated. It's hard to overstate the amount of time they want to spend on this. The 5,000 pages, the way that it's done is most students will read about 3,000 pages in the course, and then the specialization, depending on their position, they have to prepare papers for that and then debriefs afterwards, and those they have to go more in depth on their policy documents as well as some of the legal authorities. So that's how we get to the 5,000 pages. In terms of pushback from the faculty, if anything, it's been the opposite. We have a dozen faculty members who deal in national security at Georgetown, and so it's been incredible how much, where's Mary? Mary DeRosa is she's our distinguished visitor from practice. She's going to actually be speaking about the NSC process in the class and then helping to judge the simulation this autumn. We have, Bill, the dean is enthusiastically behind this. All of the faculty members who take part voluntarily, they come, they dedicate their time. We have lots of overlapping students, and so it actually complements what's being done in the other courses. So I've gotten a huge amount of support from the faculty. The cost is an issue. It's less than you might think because we're using off-the-shelf software for this, and we do it in-house at Georgetown Law. That cost will go up slightly. We actually are turning this into an invitational, and we've invited 5 schools to come compete on the NSC and to run through this. And so, in fact, I think all the schools are here today. So Syracuse and GW. Peter's going to bring 4 students, and Steve from American and Texas, UVA. What am I forgetting?
That's it.
Is that 5? And
Georgetown.
And Georgetown.
GW, American, Texas.
Yeah, that's going to be more expensive, and for that I had to get special dispensation from the Pope to do that. No, the Jesuits are not Catholic, that's right. So, sorry, that's internal politics. I should bring that up. No, that's going to be more expensive, and so ultimately to sustain this, particularly the invitational, we're going to have to find some source of an independent endowment for the simulation itself. To run it for the class, it's about $10,000. So that's kind of wrapped into, we don't do an end of the term party. This is it, right? Is that all the?
Yeah, I think that's very interesting because when we talk about national security law, I don't think most of the law schools would be able to sustain that kind of commitment in terms of, because most students are not going to go directly into the national security law job. So I think that trying to create a national security law course that is going to be useful to people in a diversity of practices. That I think that's the challenge, because 5 credits would blow up people's schedule that are, say going to practice in a New York law firm or something else, but want to have some knowledge of national security law. But I think it's a very, very interesting.
So I will say that's one of the reasons we wanted to open it to other schools, because you might only have a limited number of students that absolutely want to do this, and because it's something that institutionally we're completely dedicated to, with our institutes, with all of the activity around this, the LLM program, the journal, we have a lot going on, that we actually want to create a forum where before the students enter the field, they get to know each other at other schools too. There's a certain amount of networking and getting to know each other and opportunity there. So I would say, I'm sympathetic. Not all of our students go to national security law.
Have you thought about doing a exercise that focused more on entry-level positions? In other words, because it sounds like what you're doing is people who'd be at a level that most of the students aren't going to be up for 25 years. And I'm wondering if maybe we ought to give some thought about more of an entry-level exercise where people, the year after they're out of law school, might be faced with, as opposed to, the interagency process at the principal's level.
Yeah, I think that's a terrific idea. One of the things that we have the students do is afterwards they have to write a paper reflecting on where they screwed up in the exercise, or where they felt uncomfortable, intensely uncomfortable, or where they felt like they needed to be better prepared, and then come up with a framework to prevent that from happening in the future, regardless of what field you go into afterwards. And so there's an effort to take the experiences of the exercise and create this, and this is part of that future learning, so that they can say, okay, in the future, I need to debrief myself to look at incidents that occurred. Where was I uncomfortable? Did I not show leadership that I could have? Why didn't I? What happened? So that their learning continues and come up with a framework for how to think about this regardless of which practice they go into.
That's great. And how do you grade them?
Oh, the grading. Yeah, so the grading's interesting. So we grade them on their papers, we grade them on their class performance. I actually am a big fan of the Langdalian method. I think it has its place, so we use the Socratic method during the doctrinal portion of the course. 10% of their grade is based on that. They have papers, they're graded during the simulation by the faculty, not the judges. The judges are there for feedback to the students, so that because the professors we read all of the documents, we see all of their classified communications, we see their public communications, their performance in front of the camera. Then they're graded on a paper they submit, and then they have a 90-second oral briefing they have to give, and if they run over, they drop a grade in that portion for every 5 seconds they run over 90 seconds. We want it to be clear to them that they have to learn how to deliver this information quickly, succinctly, and to a decision maker in a way that the decision maker is going to be able to absorb it.
Elizabeth.
I have 2 comments. First, as a girl of the 50s, I love that comment, but I would just like to add to it, we're not teaching civics anymore either, and so we really have kind of blanked out any understanding of our history. It's not just starting in college. To the comment about how can this be relevant, I was really struck when I was serving as general counsel of NSA, not so much about the national security information I was gathering, which was itself pretty amazing, but the role just stunned me. I had not been prepared to serve as a general counsel. Subsequently, when I went to the University of Wisconsin as a general counsel, I remember saying to them, you may not be prosecuting 3 spies, but I believe what I learned in those general counsel roles translates. And I do think that's true for all of us. Someone commented that we tend to educate our lawyers to educate other lawyers. And yet that's not what law is principally about. You have to be able to do that, but you've also got to be able to work with people who are not lawyers. And I'm not sure we do that as consciously as we ought to. We also need to educate them to write in ways that a non-lawyer can understand and to speak in ways that a non-lawyer can understand. And so I think while you've got a particularly exotic context, the lessons translate into many other areas.
I very strongly agree with that.
Do we have time for one more question, Bill? No one wants to be the last question before dinner.
I'll say, good evening, my name is Robert Solnick, I'm an MPA student here. I really liked, sorry, this is a question for you, Cindy. I really liked the idea of providing students with a course on conventional warfare. I think that's very interesting. But given kind of the changing dynamic of the security environment today, where conventional, or a lot of people would argue that conventional warfare is becoming a thing of the past, and we're starting to confront more asymmetric threats. I was just kind of wondering, what are your opinions on providing students with a course that went into asymmetric warfare, talked about how that poses a serious challenge to conventional forces, especially given the United States is by far and large far superior to our adversaries in conventional forces, that anyone that seeks to confront us will seek to avoid that particular confrontation.
It's interesting how it's worked in our group. You might call us the dinosaurs of the security studies world, because a lot of us do, we sort of got our educations and did our initial work in the Cold War. And so we've got nuclear experts, we've got people who think about the balance of forces, we've got people who are great on Battle of the Bulge, and it's actually our students who have taught us about counterinsurgency operations. It's our students who have taught us about asymmetric operations. And we look to our graduate students to do that, to teach us and to teach each other. And so I think one of the best things we do in our program is make sure that the students are teaching each other inside class and from one class to the next class. So there's a certain amount we can do ourselves, but then there's a lot the students just do on their own. They set up their own work in progress seminars, they set up their own ways of testing and challenging each other, of studying together. And somehow it works. So in the end, our courses do include those things. And our course on conventional warfare has a section on counterinsurgency, and we have all these ones on, a whole course on interventions. Our course on Asian security includes discussions of that. So it does enter into our courses, even though we are behemoths, old guys, and not the ones who cut our teeth on that kind of thinking.
Thank you very much.
Great. Well, please join me in thanking our panel.